Notice of motion for summary adjudication. Issue 1. The first cause of action. Notice of motion for summary adjudication. Issue 1. The first cause of action for assault. Plaintiff is at all times entitled, as a matter of law, to remain free from unreasonable search or seizure. And, in seizing and searching the plaintiff in her home, caused injuries. Moving parties undisputable material facts and supporting evidence. 1. Defendants entered the plaintiff's home. Without a warrant, without exigency, without consent, and without probable cause. 2. This caused emotional and physical injury to the plaintiff. 3. Police log states plaintiff not allowing social worker Roger Rodriguez into home. Undisputed material facts for purpose of this motion. Issue 2. False imprisonment. Plaintiff is at all times entitled, as a matter of law, to remain free from unreasonable search or seizure. And, in seizing and searching the plaintiff in her home, caused injuries. Moving parties undisputable material facts and supporting evidence. 1. Plaintiff was held outside her home against her consent and will. 2. This caused emotional and physical injury to the plaintiff. 3. Police log states plaintiff not allowing social worker Roger Rodriguez into home. Time of police assistance request until time of cleared event was an unreasonable amount of time. Undisputed material facts for purpose of this motion. Issue 3. Intentional infliction of emotional distress. Defendants entered the plaintiff's home after confirmation of children at nanny's house and no reasonable purpose to enter the home, causing traumatic emotional distress. Moving parties undisputable material facts and supporting evidence. 1. Plaintiff shouted, "You don't have a warrant, you may not enter my house." The female deputy immediately shouted back, "I don't need a warrant," then proceeded into home. 2. As clearly intentional purpose to show power, force, and fear to the plaintiff, and succeeded in causing distress and emotional damage to the plaintiff. Undisputed material facts for purpose of this motion. Issue 4. Violation of civil rights. Defendants violated clearly established civil rights of the plaintiff by entering her home and searching through her house, all a volatile intrusion of her rights to be safe from government intrusion, and by doing so caused emotional harm and damage. Moving parties undisputable material facts and supporting evidence. 1. Defendants entered the plaintiff's home without a warrant, without exigency, without consent, and without probable cause. 2. This caused emotional and physical injury to the plaintiff. 3. Police log states plaintiff not allowing social worker Roger Rodriguez into home. Undisputed material facts for purpose of this motion. Issue 5. Slander. Social worker Roger Rodriguez told plaintiff's mother the plaintiff did drugs and had a suspended license for a DUI, which caused immediate divide in familial relations and injury both emotionally and financially were direct proximate effect caused by false statements. Moving parties undisputable material facts and supporting evidence. 1. Immediately after home invasion, plaintiff spoke with her mother on the phone in which disclosure of what Roger Rodriguez told plaintiff's mother. 2. An email stating the unsure nature of truth after these accusations will show the immediate harm directly caused by this slander. Any claims of drug use and/or DUI can be obtained in background checks that will show no drug-related convictions exist and no DUI exists on plaintiff's driving record. 3. Emotional harm and financial losses due to inability to complete remodel and home cell control relinquishment were caused by the false statements to plaintiff's mother by Roger Rodriguez. Undisputed material facts for purpose of this motion. Issue 6. Breach of duty. The officers should have known not to participate in the search and seizure of the plaintiff and her home, and by doing so breached their duties, causing damage to the plaintiff. Moving parties undisputable material facts and supporting evidence. 1. The requirement of a search warrant is so well established that any reasonable officer would know it. Undisputed material facts for purpose of this motion. Issue 5. 2. The fact that the other two officers did not object to the warrantless entry, the clear non-consensual seizure of self and home, participating in coercion. 2. Cooperate by signing a blank paper, arresting no one, seizing no evidence claimed, witnessing the female officer arguing with the plaintiff about storage of refrigerated smoked turkey, is not negligence, but willful participation in breach of duty. A. Clear duty to protect persons, good citizens, of harm, including physical restraint of a person and their property without just cause, and for an unreasonable amount of time. 3. By this failure of duty, the plaintiff has been harmed directly as to have trust and security issues to the extent of jumping and or shaking in the presence of Sacramento County officials. The trauma from this event is an emotional damage that should be awarded punitive damage for a clearly established civil rights. Entitlement. Issue 7 Monel-related claim. The deliberate indifferent behavior by all Sacramento County defendants and extension oversight entities caused direct harm and damage to the plaintiff. Moving parties undisputable material facts and supporting evidence. 1. The child seizure warrant, not a search warrant, distributed to the plaintiff at 8:30 p.m. the following Friday. The attempt to gain response from the Child Welfare Department in Sacramento County from dates between the 20th of January 2017 until January 27, 2017 will support the culture and willfully indifferent behavior of the Sacramento County agencies as a whole. Single behavior. The sheriff's internal investigations found no issues with the actions of their officers, all while ignoring the plaintiff until pressed for response. Not investigating completely by not calling the plaintiff for questions to be unbiased investigation. Claiming some privacy code to keep details of this so-called investigation private, and even risk management told the plaintiff, in person, at their Pyramid building, a team was formed in response to her claim, but claim was only disclosed to be denied the claim after she called months later. Due to no response. The non-responsive ombudsman, non-responsive management, all authority possibly thought to exist by a reasonable person, were contacted and none responded. So indifferent to the event and non-enforcement of basic standards of civility were ignored. Calabretta v. Floyd, before, and Stephen Clark after, show some of the pattern and behavior towards basic constitutional rights of its citizens and the willful disregard and indifferent persona in agency culture. Undisputed material facts for purpose of this motion. Email serves as material fact in this case, and the direct emotional damage caused by actions of county defendants as a municipality is financial and exponential with time.